Right, good evening everyone, and thank you very much for logging into the Bar Council's Civil Legal Aid Seminar. After a very boiling hot day, there can be no greater pleasure than listening to three expert speakers on this subject. And my name is Adrian Vincent. I'm Head of Policy for Legal Practice and Remuneration at the Bar Council. So one of my roles is to be the executive of the Bar Council's Remuneration Committee. So anything to do with legal aid comes under my team's area. Our first speaker this evening will be Graham MacDonald. Graham is the Legal Aid Agency's technical lead for controlled work and escape cases. His role includes overseeing decision-making in this area for around 30 staff members based in the Jarrow and Liverpool offices, and making wider improvements to operational processes and to increase efficiency. Then our second speaker will be Catherine Jolly. Cathy jointly manages the Revenue and Control team at Garden Court Chambers. She oversees the billing of all areas of work, and in particular, high-cost cases and the complex cases which Chambers undertakes. And last but not least will be Bob Baker. Bob is a cost lawyer who's been working in the legal profession since 1976, not to give away his age. And in 1988, with his wife, he set up a cost drafting business. 1998, he became a member of the Association of Cost Lawyers, becoming a fellow of the association in 2003 and a cost lawyer in 2007. And he's currently co-chair of the Legal Aid Special Interest Group of the Association of Cost Lawyers. As well as the three people you can see on screen, I should also give our thanks to my policy colleagues, Cathy Wong and Hayley Page, for helping to organise the seminar, and my training and events colleague, Kyra Bartley, who who you can't see on the screen, but who is pressing all the buttons. How this session will go is our three speakers will give their presentations, and then there will be opportunities for written questions. Now, as people are speaking, if you think of a question, want it answered, then type it into the Q&A box, which you will see on your screens. So ignore the box that says chat, because we won't be monitoring that. So see the box that says Q&A, open that up, type in your question. And if you can, it would help me if in your question you avoid shorthand acronyms and stuff. So because I'm not personally an expert in this area, so if you sort of spell it out in plain language, that would certainly help me. I'll then read out your question, and then our expert speakers will give the answers. And then we're due to finish by 7:30 this evening, and you will, after the seminar, be sent a feedback form and also a copy of the slides that our presenters are giving. So straight away we go to Graham to give us his presentation.
Thanks, Adrian. Good evening, everybody. I hope everyone is well and it isn't too uncomfortably warm where you all are. So I'm just going to try and share my screen. So hopefully that will go ahead. Okay. Okay, so can everybody see the presentation? Adrian, are you able to see that?
Yes, that's working. Thank you. We can see it.
Wonderful. That is a big relief. Okay, so as Adrian mentioned, my name is Graham. I'm based with the Escape Cases and Mental Health Unit within the Legal Aid Agency. So primarily looking at controlled work, but also some certificated work in relation to court protection and other deprivation of liberty issues. So
has Graham's sound just gone off, or is it me?
I think his sound's gone off.
We just pause, Graham. If you can hear us, maybe there's a mute button being pressed by accident or something. We'll just pause and see if your sound can return. I think what I don't know is if technically we're able to make Graham stop sharing his screen, and we might have to move to Kathy's presentation and then Graham come back as the second speaker once his sound returns. Kathy, can you try pressing your button to share your screen, and that might mean you then take control, and then you can give your presentation, and then we'll come back to Graham.
Unfortunately, it says I cannot share mine while someone else is participating.
Okay, right.
Kathy, try again now.
Yes, yours is working, Kathy. We're seeing your screen now. So if you unmute yourself and kick off, and then Graham will hopefully not be too offended that he then gives the second presentation.
Okay, that's fine. My name is Kathy Jolly, and as explained previously, I'm one of the heads of revenue and control at Garden Court Chambers. This presentation is from a Chambers perspective, and it's the best practice that we try to adhere to. These are only my views, and you may work in a completely different way in your chambers, and that may well work for you. I am going to cover a number of subjects, sort of subheadings with regard to best practice in these areas. So I'm going to start off with legal aid certificates, looking at billing, enhancements, CCMS, payments, and then finally on to high cost cases. So with regard to legal aid generally, when you're instructed in a case, the chambers are instructed in case, your barrister's instructed in case, you need to make sure that you have the correct legal aid certificate for the work that you're doing. So you need to make sure that it covers the correct court level that you're going to be instructed to do your work in. Does it look like the limit is going to be enough for your work? But it's not just your work, it's the solicitors, it's the whole case. Check the date of the issue of the certificate. Is there any work done before the date of issue? None of this would be covered by the certificate. You're also going to need the date of this issue to help you apply for a payment on account, which is something I'll talk about a bit later on. And if you've got a QC instructed, does the certificate allow a QC to work under this certificate? If, as an example, you've got several members of chambers involved on the same case, have you got scope for more than one barrister on your case? On the certificate, sorry, on the certificate. Okay. With regard to billing, it's really important that council bills their work regularly and promptly, that they don't just leave it for years to bill the case. The billing at that point is less likely to be accurate, and council might be doing themselves down on the time they've spent. You could come across issues also where there's been little left on the certificate if everyone has billed their work before your barrister. The solicitors, as an example, other counsel could have billed, and your fees could be reduced and not included, and your enhancement claim reduced. You need to detail the billing. Council doesn't need to write a paragraph for everything that they do. However, the more detail, the better, as it's going to be difficult to justify if you just claim prep or telephone con and you haven't got any details. This will also assist if council wins the case and it becomes subject to a cost order. And when you're converting your fee note to inter partes fees, you're going to need to be able to justify your fees, and detail will be required. Council needs to include enhancements and justification for these enhancements. I'll move on to that a little bit in more detail in a few moments. VAT, is this applicable? Certainly in immigration cases, does the client have leave to remain? Don't claim the VAT if it's not applicable, because the legal aid agency will pay you the VAT. Ask solicitors to confirm the VAT status of the client in writing for your records. We use Lex at Garden Court, and we have a template which we send to the solicitors by email, and it asks them to confirm the VAT status and what country the client is from. If, as an example, you do judicial review work and permission is not granted for the judicial review, you're going to need to write the work off in relation to the JR, because you can't claim that. However, it is possible to claim any work in relation to the funding, but you need to be able to distinguish what this is. To get payment of the final claim in a CF1A matter, you've got to upload that once you receive notification, either from the CCMS, or from your instructing solicitor. But the solicitor needs to have uploaded their final claim before you can submit your final bill. It's really important to coordinate the submission of the final bill to avoid rejections. There are often problems with figures that don't match, even down to a small amount, and you may need to ask the solicitor to amend the allocated amount so that the bill can be processed. I'm just going to touch on some issues with CCMS rather than going through it line by line, because I'm sure lots of people know what they're doing with that. But
sorry to interrupt, Kathy. Just we are following you very clearly. I can just only see your front page of your PowerPoint screen, and I don't know, you're probably pressing the buttons as you go along, but it's not appearing on my screen as being moved along. So you can carry on talking without it, and people will receive the. Oh, hang on, there we are. Something's happening now.
Sorry, I think I must be pressing the wrong button on the laptop. Sorry, on my mouse. Hold on, let me get to where I am. I can see it in front of me, and I was thinking. Right. I'm back here. Right. Sorry,
lovely.
I do apologise for everyone. All civil work built on a CF1A form, including high cost work, is claimed on CCMS. Each barrister has their own login, and each barrister has to have their own fees allocated. And you can't claim your final bill until the solicitor has submitted their final claim. Billing line by line and repetitive entries for court level, barrister level, etc. on the CF1 cases. That's quite time consuming. Once again, we have to match the amount allocated to us on CCMS for each barrister. And we do sometimes have an issue if our fees are pennies different to the allocation. We find that the software that we use, Lex, seems to round the VAT up on the fees, if you're claiming that, and CCMS the VAT down. Oh, I think I've gone too far now, goodness. Exceptional funded cases. So we deal with quite a lot of inquests at Garden Court, and you also bill these on CCMS. However, this is much easier than line by line, because you can claim a total advocacy fee and another option for claiming your disbursements. Something that's come in recently to help during the pandemic is that it's currently possible for solicitors to claim a one-off payment from the legal aid agency for work in progress on legal help matters to do with inquests. I think this runs until July this year. High cost case work is also claimed on CCMS, but on a separate section on to the CF1A standard codified rates. So going back to what I mentioned about enhancements, so the following maximum percentage enhancements that you can claim for any work you've done in the county, or someone's done in the county court, is up to 50%. In the upper tribunal and the High Court and the Supreme Court, Court of Appeal, it's up to 100%. And court of protection work is always 100%. If council's going to claim an enhancement, they need to justify why they are claiming it. It's simply not enough to state the matter was complex and I'm a senior barrister. Detail needs to be added to the justification. An outline of the case and also a brief synopsis about them and the work that they have done before, which is relevant to this case. Enhancements are not guaranteed and the amount allowed may be reduced or not paid at all. We have had a number of cases recently where enhancements have been reduced by the legal aid agency, and we've appealed this decision and we have been successful on a couple of cases. Excuse me. Another aspect in relation to enhancements is that a solicitor may ask you to agree to a maximum uplift, so the limit available is shared between counsel and the solicitor. This needs to be considered when taking on work and being able to provide a fee estimate what work and uplift is likely to be claimed by counsel. This needs their involvement to avoid them not being able to claim the fees that they might wish to. If the case changes during the course of the work, becomes more complex or has an additional complex area, then the enhancement can be amended. You can't claim an enhancement on your travel and waiting. If you have two barristers instructed, check what percentage enhancement they've claimed, because it would be unusual for one person to claim 10% as an example and another 50% in the same case at the same stage of the matter. Counsel can bill their time for completing the CF1A form. However, you can't claim an enhancement on this. Just carrying on from that before I move on to the payments, I was just going to say that when you submit your final bill to be paid, you have to provide documents in support of your submission. And you can't do that until after you've received a notification to do so. And occasionally, you don't get the notification, then the bill's rejected because you've not added this documentation. And if it's rejected, you have to resubmit your claim and wait for further notification. So it's a bit of a two-pronged approach with trying to bill your case. Now, payments on account. There are currently 3 ways that you can claim a payment on account on CCMS cases. So, but first of all, you need to have your solicitor allocate costs on the CCMS so you can apply for your payment on account. You can claim up to 80% of the fees billed, less the enhancements. Don't submit a payment on account claim with your enhancements, just in case they're reduced or disallowed, and then you'd be owing money rather than the barrister would be owing money. So the first way you can claim a payment on account is on the anniversary of the certificate. It's now possible to claim within a window 3 months after the grant of the certificate, and then every 3 months up until you've received 80%. Another way to claim is to claim 6 months from the date of a taxable judgment, so of a hearing. That's called the date of taxable judgment. This is often a quicker way to get a payment on account and can be claimed choosing the option, no final payment. You then add the date of the taxable judgment hearing, and you're asked to provide a fee note. The final way which you can claim a payment account is a hardship payment. During the current pandemic, it's been possible to claim a hardship payment on CCMS. The pandemic, as I said, has been seen as hardship for council, so there's now an option to claim under this criteria. It must be after 12 months from the certificate issue date, regardless the payment window or whether you're doing the no final payment received guidelines. There's no time limit for the claim. The certificate can be issued at any point in the past. Now, there are sometimes payment problems, which I just thought I would touch on, which we have an issue with quite regularly. So you've applied for a payment on account and then you're able to submit your final bill. And the final payment is often paid and the payments on account are not recouped at the same time, which means you've got a big overpayment for your barristers. So until the legal aid agency have processed the solicitor's final bill, they will not recoup the payments on account made to council. This can result in overpayments and then recoupments at a later date. This can also cause a problem if you get VAT paid on a payment account when you shouldn't have done, as a case which wasn't VAT applied. And this can cause overpayment issues. And occasionally you also get duplicate payments on account being processed. So you end up with double the payment that you're expecting. Sorry, I think I've jumped 2 slides there. I've gone past myself now. Right. So now I was going to speak a bit about civil high cost cases, because this is where there seems to be an awful lot of questions and queries, and certainly in my chambers there seem to be lots of queries about this, and we do quite a lot of them. So when a legal aided civil case is complex and expensive, it may need to be managed under a high cost case contract. And this is any civil case where the final costs either to settlement or final hearing are likely to exceed £25,000. They're managed by the exceptional complex case team. All areas of civil funding are covered, including associated judicial review. To ensure that you are recognising the potential high cost cases, you need to watch out for the following key indicators. So if the costs are approaching or have exceeded £10,000, if the sum of the costs for this barrister and solicitors is £25,000, then this will mean it is a high cost case. Another example is if the certificate limit has been extended to £20,000. If your barrister provides an estimate for future work and it's a lot of hours, then that would be sort of a highlight or an indicator too. If you've got a QC instructed, either with you or there's one externally, that's another indicator. If you've got multiple barristers instructed. If there's a hearing booked for a number of days, or quite simply, if the barrister or the solicitor say to you that they think that this is likely to become high cost. Sorry, so I think I've covered that slide as well. So there are various action points that you need to consider if you're dealing with a high cost case plan. So there's billing and forward planning with estimates that they need to be up to date, and we always need to remind counsel of this. The information provided is what will be used in the case planning of the case. The case plans need to be checked and agreed before the barrister acceptance forms are signed. Well, that's generally how we do it, to be honest. You can sign the barrister's form on their behalf, but with their consent. However, once that's been signed, you can't get it altered retrospectively. That's rare. So this could mean that you've billed for work that you might not actually get paid for. So once again, your billing and forward planning estimates must be up to date. The information we provide is what's going to be used for the case planning. So once a case is billed under the high cost case contract, you're able to bill counsel's fees at prescribed rates until that 25 limit across the case has been reached. These are called your pre-contract costs. This is the total across the case and includes the solicitor's fees, counsel's fees, experts' fees, etc. But once you hit that limit, the following rates apply. So your junior counsel would go to £50 an hour, senior junior 90, and Queen's counsel £90 an hour. and you can't claim any enhancements on these rates. Sorry, I seem to be going ahead the whole time. If a case is, no, I've got to go back. Oh no, that's right. I apologise. If a case is deemed to be of overwhelming importance or wider public interest, it is possible for a 30% uplift to be added to these fees, so that would increase them to £65 and £117 per hour respectively. This is usually agreed in advance by the legal aid agency, and travel is paid a quarter of the relevant rate. Another issue to, another aspect to raise is that if a barrister is instructed in a case where there's a high cost case contract already in place, so you've taken it on from another set of chambers or another barrister as an example, you can apply for the prescribed rates for some of this work. The first £5,000 of the fees are ring-fenced at the prescribed rates, and this is seen as an incentive for the new barrister to take the case on, otherwise they'd be taking it on at a much lower rate. If two barristers are instructed in this way, then the 5,000 is split, with 2,500 for each newly instructed barrister. So certainly it seems to be that there are some misconceptions. Certainly I come across this in chambers. So no case starts out as a high cost case. You need to ensure that council has billed as much as they can before the low hourly rates are applied. And any delay will mean that solicitors will use the scope available before you realise. This information relates only to legally aided cases. No CFA, private or IP case will go high cost, despite what you might be told. You may need to amend the billed fees on your system once you've been told the case plan has come into effect. So that might mean amending it back and the fees will go down. The plan is based on time and not value, so you need to add your hours rather than your fees for future planning. Oh, sorry. Get there in a minute. I was just going to raise some final thoughts with regard to CCMS and some issues that we certainly have, or grumble, so to speak, is that if you upload family adequacy claims, you can do as a bulk upload. And we were at one stage told that this would be extended onto the civil work, but unfortunately that's not happened. And that obviously would save an enormous amount of time and avoid any errors through manual submissions. I would also say that the support section on CCMS is not very effective, and in my opinion takes a long time to get a response, and it doesn't always appear to offer resolutions to problems. I have used the chat on the training module, but that seemed to be much more focused for assisting solicitors rather than barristers. It would be very helpful if we were able to ask the legal aid agency to pressure solicitors to allocate cost to council, because we have a massive issue with that, with cost just not being allocated. Solicitors saying they don't know how to do it. But as we are a disbursement and don't have a contract with the legal aid agency directly, this seems unlikely. I think I did, sorry. My final screen, I think I've missed this bit as I was going through, is that you can currently claim under a payment on account under a contingency form for cases which are pre-CCMS. What you do is you complete this form and send it to events at the legal aid agency, and if there's enough scope on the certificate, you can get these fees paid where previously you've not been able to because it's a paper claim. I don't know how long that's lasting for. I know that was brought in as a contingency measure during the pandemic, but we've certainly been using that, and as far as I'm aware you still can. Sorry, excuse me. I'd just like to say that's the end of my presentation. Sorry you couldn't see half of the slides at the beginning. Thank you for listening to me. I hope that some of it has been informative and of some use.
Thank you very much, Kathy. The first questions appeared in the Q&A box, and I encourage other people who are listening, as the next presentations go on, if you have a question you want to ask, type it in the Q&A box, and we'll pick it up after our 3 speakers have spoken. Now, Graham's internet seemed to have been fried by the hot weather, but I can see he's back online now. And I think over to Graham to have another try with your presentation.
Thanks, Adrian. Firstly, is the sound okay?
Yes, we can hear you. Yep.
Okay. How far did we get into?
I think we were only had your first slide up where, and then you cut out. So I think if you start from like slide 1 or 2.
Okay, no problem. Right. Okay, is that okay?
Yep, all well.
Okay, let's hope we don't have a repeat, and apologies once again, the joys of technology. Okay, so apologies if any of this has already been covered. Unfortunately, it took me a little while to reestablish a connection. So as I may have mentioned before I cut out, the idea is to just give some hints and tips as to how to assist with getting your claims successfully through the LAA's various procedures, hopefully at the first time of asking. So as we know, you are able to claim your costs, or solicitor can claim them and then reimburse you, but irrespective of which method is used, the key issues remain the same. So as I mentioned, disbursement vouchers, although the rules are slightly different for providers who are contracted with the agency, the disbursement vouchers do help us contextualize the work undertaken. One of the key aspects for us is if instructing solicitors and counsel can liaise in terms of the claims and if they're submitted not necessarily on the same day, but in and around the same time, that really helps us. The 2 claims not being submitted at the same time or around the same time is one of our main reasons for claims being rejected, and that crops up on a routine basis, kind of month in, month out. In terms of the invoices presented, then it really does help us if it's bespoke with the client's name clearly visible, the date and work completed, so the prep, travel, attendance, advocacy, the time taken, and the hourly rate that has been applied, plus the value of each component item of work, and also the overall value of the work undertaken. So in terms of the certificate, the scope of the certificate is very important. So always worth checking that you are clear on what the scope of the certificate and the existing cost limitation is before undertaking any work against the same, and also worth double checking that you are clear on what the scope means if perhaps the wording isn't 100% clear. Always double check, and of course that will prevent undertaking any work that is either outside of the scope at the time, or if the costs are above the cost limitation and causing any issues that may present upon cost assessment. Another area alongside claims not being submitted around the same time as the provider is in respect of enhancements. Again, this is something that we see each month in terms of our number of appeals we receive and our assessment reasons when we review that data. So what we do tend to see is generic reasons that are quite often copied and pasted from one case to another in terms of justification for enhancement, just in terms of counsel's experience or number of years at the bar, or just generic, this is a complex matter. That doesn't necessarily assist the caseworker in making a decision as to whether the enhancement is justified or not. And really what we're looking for is either a client or case-specific justification that is bespoke to the case itself and the enhanced rate being claimed in relation to that case. And that really does help us. I'm sure maybe quite a lot of people on the call have got experience of their cases, of their costs being reinstated on appeal without the necessity to send the matter to the independent adjudicator. And quite often the information that is provided on appeal is, is more than adequate to allow us to allow the costs claimed. And if that kind of information is on the file in the first instance, or on the claim rather, then that would allow us to authorize the enhancement claimed at the first time of asking. Now, it doesn't necessarily need to be mountains of text, bullet points are fine, but it's just that that justification that is bespoke to the case that really helps us make that decision and allow the costs at the first time of asking. In terms of the pandemic, I know I said that at the first time I tried to do the presentation, I wasn't going to speak very much about pandemic, but just in case those of you who potentially are seeing an increase, unfortunately, and perhaps where you're waiting for payments on certificates where the firm who instructed you has stopped trading due to bankruptcy or insolvency issues, then if you could send a query through CCMS in respect of the relevant case, rather than perhaps sending an overall list of cases where you're awaiting payment, it will allow us to look into those cases on a case-by-case basis and get back to you in respect of those impacted certificates. In respect of payment on account, I know that Kathy was looking at POAs, so just to give you a run through of what the current rules are. So you can claim up to 80% of incurred costs, which has increased from 75% from October 2020 onwards. You can claim after the certificate has been in place for 3 months, where it was previously 12 months, but the 3-year maximum is still in place. And then after that, you can claim further POAs every 3 months. And just to remind you really that CCMS is able to do the calculations for you in terms of payment windows and where the claim hasn't been finalized within the 6 months of the final POA, and will give you the appropriate notifications and whatnot. So with that in mind, when CCMS does prompt you to submit your claim, it's really helpful if that evidence can be sent through. And linking back to the start of the presentation, it allows you to, if you can, link up with instructing solicitors around the submission of claims, whether they're the final bills or POAs. If the solicitor submits their final bill, then you will be asked to submit yours within 2 weeks, and the system is automated, so it will return the claim after 14 days if it hasn't been submitted. So that's something to bear in mind, that the clock is ticking once you get that prompt. And of course, VAT should only be claimed whether it's a POA or a final claim where it's applicable, including where the client doesn't attract VAT due to their right to remain status. So in terms of POA guidance, chapter 15 of the Finance Handbook, the CCMS user guide, and also the VHCC guidance document that are all available at these links within the presentation that will be sent afterwards. So you'll just be able to click on the link and it will take you through. The VHCC guidance is bespoke for council, so that is a very useful document. Moving forward, we have an amendment to CCMS in terms of what future submissions will look like. So just to spend a quick moment in terms of what that might look like. So the system is called Apply. Some of you may have heard providers or clients talk about it. So it's not a new case management system. It would be an amendment to CCMS itself. So at the moment, it's in a testing phase, and ideally it will make it easier for clients to upload their details into the application service. So we've got just shy of 50 solicitors on board in terms of firms rather than fee earners, who submitted 3,500 applications in respect of domestic violence proceedings. But as the testing increases, it will be built up incrementally, as it says there, where we can kind of build on the system as we go, rather than older ways of testing where we wait until the system is built completely and then have a start date. This allows us to tweak and make improvements as we go. So as Apply is rolled out, it will be through CCMS. So you'll still use and submit your claim for costs through CCMS. So at the moment, there's no direct change for council to make, but just in case you hear any clients or more likely solicitors referring to having submitted their applications through the Apply service, that is what they're referring to, and you don't need to do anything differently at the moment. And then really just some useful contacts to kind of build on what Kathy was discussing in terms of CCMS queries. So, you know, if you have a general case query, if you go through the general inquiry feature in CCMS, you know, we can try and get back to you, you know, as quickly as possible on that particular case. So of course, include the client details and the case reference, and we'll be able to have a look at the case for you. Contact Civil is exactly that. It's a contact point for all civil cases, but generally, if it's to do with old paper claims, that will help, because the CCMS feature with the general inquiries is more useful in that area. And then, of course, just to highlight the high cost issue on family issues, high cost cases for family matters. And then, of course, if you're unhappy with a claim that's been rejected, you can use the reject fix service, and we'll get back to you in 24 hours. And then, as Kathy mentioned, there is the for IT issues, the training and support website. If you can't find the answer within the guidance document. And then there is kind of online support as well. And then the more general payment or provider issues are in those final two accounts there. So probably a useful document to keep to hand once the slides are shared, as I appreciate we do have a lot of different contact points, and we're a long way away from being an organisation with just one point of contact. But in addition to those, you can also contact us via Twitter. So we do have the general social media messages, and also a query service which you can use at the LAA help team, which the customer services team will get back to you certainly within 24 hours, I think. And if they can't answer directly, they will liaise with the technical experts within the case management teams to get you this response as quickly as possible. So that is the conclusion of the general hints and tips for my presentation, and apologies once again with the earlier technical problems.
Thank you very much, Graham, and thank you for your perseverance with the computer troubles. And we now turn to Bob Baker to give us his insights, please.
Thank you very much. Let me try and set up my screen so you can see it. Can you see that?
Yep.
No. Yes?
Yes, I think you need to, that's
yes.
it, yes, all
Right.
well.
I'm seeing the right thing now.
Yeah.
Oh, no, I'm not seeing the right thing. I lost my words. How do I find them?
What we can see is your slide saying civil legal aid costs, reducing billing delays.
That's right. I just moved something off my screen. Good evening, everyone. I'm Bob Baker, a cost lawyer with a very varied caseload of legal aid and non-legal aid cases. Thank you to the Bar Council for asking me to come along today and give, from the solicitor's perspective, a view of how we can all try and make our increasingly complex legal aid system work and provide remuneration for members of the bar. Barristers' clerks are traditionally the people who convert the barrister's time into money. Cost lawyers and cost draftsmen do the same for the solicitors. I need to say at the outset that anything I say here is my own view and is not an official policy of or statement by the Association of Cost Lawyers or of my own committee, the Association of Cost Lawyers Legal Aid Group, of which I am the co-chair. Before we start, I thought I'd do my bit for Cornish tourism, as I live in the West Country, and share with you the view from St Ives looking northeast with the usual seascape, spoiled, or perhaps enhanced if you're one of the G7 visitors. We had a visit from a number of Navy warships last week. This one is HMS Tyne, guarding the great and the good at the G7 summit last week. My neighbour Jen took this picture, so credit to her for that. Right, back to business. In civil legal aid cases, as you'll all know, despite the massive guidance and help available online from the LAA on the various training pages that they have helpfully produced, there are problems and delays that we can all encounter. For the purposes of this talk, I'm going to deal only with CCMS processes, as the old paper style claims are now fairly few and far between, and most people seem to know what it goes on with them. This is a list of essential reading. It's not an exhaustive list, but these are the main things that you might want to look at, and they will set you on the right path for most of the time. They can all be found via the gov.uk legal aid pages on the website. A lot of what I've said, or what I'm going to say, has actually already been said by Kathy and Graham, so I apologise for repeating certain things. POA claims can be made during the ongoing cases if the solicitor has allocated the funds for counsel on CCMS. It's good practice to keep in touch with the solicitor in the case and ensure that the funds are allocated at the right time to enable POA claims to be made by council as the case progresses. As we've heard, it's 80% of the total cost that's paid in response to a POA claim, so it is worth doing. For final bills, you'd be wise to ascertain the type of bill being produced by the solicitor, and also whether it includes any enhancement for the solicitor, and if so, how much this is, and is it the same percent as that which council wants to claim as well. For myself, I always contact council's clerk as to the timing of the submission of bills to make sure they all go in at the same time, to avoid risks of rejection of one or other bill for not being available for assessment by the LAA caseworker at the same time as the other bill. We have bills rejected on this issue from time to time, and good timing does help to avoid it or keep it to a minimum. In high cost cases where it is not unusual to see many stages, sorry, I've lost where I was. Here we go. Press the wrong button. In high cost cases where it is not unusual to see many stages, it is not possible to claim council's fees until the very final stage after the certificate has been discharged. So do claim POAs as the case progresses and liaise with the solicitors as to the progress of the stages so that you're ready to submit the final fees at the right time. This can take many months. Always demand to be provided with a copy of the legal aid certificate before you carry out any work. Check that the case type that you are doing is permitted by the certificate and there is scope for counsel to do whatever it is he's being asked to do. If work is out of scope, there is no chance of getting paid for it. And if there is a limit on the certificate of, say, £1,350, as we often see, there is no point doing work to a greater value of that unless you know for sure there is a higher limit available. Out of scope claims are a common issue caused especially where the solicitors do not supply a copy of the certificate when counsel is first instructed. They ought to send you all amendments to the scope as the case progresses so that you can keep an eye on the case, but often this is overlooked by solicitors and busy counsel's clerks. Other things to do. In very high cost cases, lack of a signed barrister acceptance form is a problem, and it's our practice to advise solicitors and counsel to get the contract signed and uploaded to the LAA as soon as a case is registered or as soon after it's registered as possible. Without those documents, the legal aid agency are unable to issue any contract. And as the contracts for the solicitor and counsel are not fee specific, there isn't really any good reason not to sign them at the earliest opportunity. You need to be involved in the case planning so that counsel's fees are properly referenced and sought at the planning stage. If there are any changes to what is requested during negotiations with the legal aid agency after the plan is submitted, make sure that you are aware of it and a note made on the file recording what the arrangements are. We've often come across situations in high cost cases where solicitors from different chambers, counsel from different chambers doing different stages of cases are not always aware of what has been agreed or contracted. The solicitors need to supply the clerks with the high cost case plan, either when it's created or at a later stage if there's any change in how the case planning is going. As Kathy has said, the work of counsel under a high cost case plan is subject to hours, not rates. So you do need to keep on top of your barrister to make sure they're not spending too long on a case, because they probably won't get paid for it. My main message this year is the same as last year and the year before and probably for lots of years, and that is that good communication with your solicitor's billing representative is important. Most problems arise from lack of communication in my experience, and a lack of adequate detail and reasons for enhancements sought and missing documentation are the other reasons. We've already heard from both Kathy and Graham about enhancements. and I repeat, well, I don't repeat it, I echo what they've said. Changes of chambers present problems. We had a case last year where counsel was instructed on 2 different matters for the same client, and he prepared 2 advices, 1 on each legal aid certificate. He then moved chambers not once but twice, and we could only find 1 fee note for 1 advice. And we had a hell of a job to sort that one out to get counsel paid. So if counsel moves, you need to make sure you know where he's gone and what the fee arrangement is. Regular and effective communications with solicitors is essential. Get to know your solicitors and their billing teams, and identify those who really know what they're doing and those who may not have quite the same level of experience and resources available to them as a more experienced practitioner might have. They will often need more help from you to get what you want, which is payment of your barrister's fees quickly and correctly. Just by sending a fee note through may not be enough for some firms. Some firms do not have a team of cost people in-house, and you might have to deal with a secretary who knows very little about the legal aid system. Keep in touch with somebody who does know, if possible by telephone, and work out your own system for making it easy on yourself and also for your solicitors or those handling the billing process. Allocation of funds in CCMS cases is vitally important. Files come to us and we often see that counsel's fees are either not allocated at all or they're wrongly allocated, including VAT, or they're just plain wrong or not updated. So you need to make sure that the solicitors are keeping up to date with their CCMS allocations. If enhancements are to be claimed, communicate with the solicitor in the case to ensure there's headroom on the certificate for enhancements. Tell the solicitor what enhancement counsel wants to claim and why, and make sure the solicitor sees the case in the same way as counsel. It's helpful if both solicitor and counsel say the same things about complexity or the various factors that go to justify enhancement. Paragraph 12 of the cost assessment guidance, any version of it, sets out the criteria for there being an enhancement at all, and it's worth reading this and making reference to it in the various applicable parts of it in your submissions for enhancement. It will help the assessor decide at the initial inspection of the case and assessment if the criteria are met, and it's a good way of demonstrating that you have thought about the criteria when working out how much the enhancement should be. It's not always 100% in the High Court nor 50% in the County Court. These are maximum enhancements, but whatever level you decide you are going to claim, you do need to justify to the assessor why that level of enhancement is appropriate. Recent statistics provided by the LAA show that in the period February to April this year, there were 97 enhancement-related appeals, 35 of which were in relation to counsel's enhancements, and 18 of them found the enhancement claimed was excessive and was reduced on assessment and on appeal. 17 claims had no enhancement justification at all and no explanation, so they were just disallowed. There needs to be coordination of the timing of the submission of final bills, as we've heard, to avoid rejection for the two not being present at the same time. Exceptional case funding cases provide for counsel's fees at these rates only. You get travel expenses but not time, and you can also claim for accommodation at the applicable daily rate for the place where the accommodation is located. The usual evidential requirements apply to travel and accommodation. They will be the disbursements that we've already heard about, but you can only claim these and get them if the estimate of costs made at the outset of the case provides for it. As with high cost cases, hopefully the solicitor and counsel's clerk will work together to prepare that estimate so you will know what is provided for. But if your instructions to act are received late after the ECF is granted, ask to see the cost estimate provided to the LAA, because what is said in response as to that estimate is the only record of the payment that we made at the end. So if the estimate doesn't provide for travel cost and accommodation, you just won't get it. I often see fee notes from council claiming all sorts of work not covered by the ECF, so please try and maintain fee notes for ECF work separately from any other work that council may be doing on the case, which may not be covered by the ECF scheme. These are my suggestions of some steps you can take to try and effective administration. We all work in differing ways, so you'll need to find your own way to make claiming fees as easy for you as you can. Try and keep up to date on every case and make sure you have all the required materials promptly before hearings have taken place, so there's no great delays. We were given some questions before we made our presentations. One related to multiple certificates and whether we should have one fee note or multiple fee notes. I have to defer to Kathy about this because she'll have more experience than me, but my view would be you have one certificate, one fee note per certificate, but I suspect that is an issue that the clerks will be able to deal with. Thank you very much for listening. If there's any questions, then we'll deal with those at the panel session that follows.
Thank you very much, Bob. So
sharing.
we do now go to the Q&A session. So we've already got 6 questions appeared in the Q&A box. There should be time for us to answer all of those and a few more that may come in. So if you're watching this and have a question, there's still, click on the Q&A box, type it in, and we'll try and come to your question. So if we start with the first questions that have come in, the first question was asking about hardship payments, and the question is, do you have to submit evidence of hardship as you had to in the past? Because I think things had changed during the COVID. Things might have loosened up over COVID, but so who's able to answer that?
No, you don't have to, as in the past. I remember many years ago you had to supply all sorts of bank details from the barrister, but you don't have to do that anymore. You just have to be prepared to support it with a fee note showing the work done. So you don't have to say anything about their hardship. It's COVID is seen as hardship to the barristers anyway.
Thank you, Kathy. And then the next question is for you again, Kathy. Mentions you specifically. Apparently you said that Court of Protection work is always 100% uplift. Question is, does that mean no justification or regardless of justification?
You have to provide a justification for any line that you put on, but you're more likely, you can claim up to 100%, even though it's heard in the county court, it's viewed as a high court case. So you have to provide the justification for any fee line, but because it's often heard in the county court, but it's seen as a high court case because of the nature and the complexity of the case. Does that help?
I'm sure it does.
Can I add to that?
Please do.
We had a series of Court of Protection cases last year where enhancements were claimed not at 100% maximum, but about 80%, 75, 80%. And they were subject to either disallowance altogether by the legal aid agency or were reduced, and they were appealed and successfully restored. So it does reinforce the point that you have to justify and justify again if you are looking for enhancements.
Thank you, Bob. And the next question is for Graham, and And in your presentation, you mentioned disbursement vouchers. And the question is, what do you mean by disbursement vouchers, and when would we use them?
Sorry, I just lost connection again. Is that
So the question is what you meant by disbursement vouchers and when would we use them?
Yep, generally, as Bob mentioned, for council, the main vouchers that we would expect to see would be around the travel costs, so train tickets, taxis, mileage, although mileage doesn't per se produce a disbursement voucher, and also if any accommodation costs have been incurred.
Thank you. And then the next question is asking if we can clarify who is classed as junior counsel and who is classed as senior counsel for the purposes of high cost case plan risk rates. Does it depend on year of call, or does it depend on the case plan in place on the file at the time?
Probably a bit of a mixture of two, I would say. We often have it where we have a senior junior, and then we also have a junior barrister on the case plan, not necessarily a silk, but a senior barrister who's an expert in the field of whatever it is. So it would be, obviously that would be somebody who was quite senior, but they may also be leading somebody junior within chambers or in another chambers. But it'd have to be agreed with the legal aid agency through the solicitors. You couldn't just decide, oh, my barrister's 20 years cool, so I'm having that higher rate. These are things that have to be agreed in advance as part of the planning. Hope that helps. I don't know.
Thank you. The next question is, once an appeal is assessed, is there an option to appeal again? In a recent case, the assessor indicated that they'd been presented with certain additional information and documentation, and they may have increased the uplift further. Does anyone want to comment on that?
Generally speaking, the contract only allows for one appeal to be submitted and considered, and so there is no formal second right of appeal, as it were. That said, we will take a pragmatic attitude, and perhaps if the adjudicator says, actually, if you could provide me with this information or send the additional documents in that weren't submitted as part of the appeal, then we will facilitate that. More widely than that, if a decision has been issued and perhaps it's just a case of the provider or the barrister, just kind of thinks, I don't like that, then there would per se be no further recourse to another appeal. But that said, that's very different than where the appealing party thinks, actually, I think that decision is incorrect based upon the rules of the scheme, the contract, the regulations, whatever it may be. And if that's the case, then of course we are obliged to look into it again.
Thank you. And then the next one's for you again, Graham. You said that we have 2 weeks to submit ours after submit bill notification, but the quote's due date is not 14 days, it's usually about 2 days. Do you have a comment on that?
Only that doesn't sound right. I mean, to only give somebody 2 days to submit is not a great deal of time, and 14 days tends to be our standard when we request further information. So it may well be that the request specifies a shorter time, but certainly in terms of what the system does, it should wait a full 14 days before actually returning the claim. So if you find that that's not the case, if you could kind of query that at the time and send that through, that would be really useful.
Thank you. I don't know if Kathy or Bob have any experience of that example that you might want to comment on.
We certainly had some bills rejected because of timing issues, and I think it is all down to communication between solicitor and counsel as to when the submissions to CCMS are going to happen. I'm certainly aware of cases where both submissions were actually made, but at different times, and bills got rejected because of that timing issue. And I think there was a time, Graham, correct me if I'm wrong, when CCMS was playing up a little bit. Last year, I'm thinking of, when we had a sort of clutch of these that were a bit of a problem. But I haven't had any recently.
I think. Sorry, thanks, Bob. Yeah, I think that's absolutely right. Obviously, with CCMS being a web-based system, there will from time to time be IT problems, unfortunately, but and there were some last year. But generally speaking, as a default way it's supposed to work, it should give you that those 14 days to align with the instructing firm's submission and give you a reasonable amount of time to get the admin on your side right and submitted.
Thank you. And I'm guessing the next question is probably one for Kathy. Is there an easy way for more than one chambers to have access to CCMS for a barrister who has moved chambers?
There's not an easy way. What you have to do is you have to get your administrator who deals with your CCMS, who uses the CCMS system as the administrator. It's our IT guy for some reason. He has to set up a profile for somebody if it's in another set of chambers, and they can then access our system, but only, I think, they can only see the barrister who is also with them. However, I have also heard recently that this hasn't worked terribly well, and we've had to bill for another chambers because they weren't able to access it. So it is a bit of a problem. I don't know whether there is an easier way to go about it, Graham, but I think often when the barrister goes, they take all, they obviously let the legal aid agency know that they've changed chambers, and so we then don't have access without their permission to get into their billing. So it's not an easy situation.
Yeah, I'm not sure, to be honest, Kathy. I would be guessing really, because what providers and councils see on their side of CCMS is completely different than the interface that we have on the LAA side. So I suspect that it would, in terms of the list of contacts at the end of the slides that I've sent over, it might be one to take up with the provider records. They would probably be able to give you a more comprehensive answer.
And we have our next question, which is, I think, on the same subject, but making it even more complicated. And it maybe has your same answer, Graham. The question is, how do you input fees on CCMS where the barrister has moved chambers and is claiming non-London fees from when they were based in Manchester and are now claiming London fees? CCMS has automatically gone to London rates. I think it is non-codified screen with the justification added to the hourly rate. Does anyone want to comment on that?
My understanding is that although CCMS does have the kind of the hourly rates engine built into it, so it won't. The idea being that it's useful, so it won't kind of allow you to use the incorrect rate. to thereby avoid unnecessary rejections. I think if you do have something where the codified rate doesn't apply, then you would put it through as an ad hoc item with the explanation and the justification, so the caseworker can see that it's something outside of the ordinary.
Thank you, Graham. The next question is picking up a point that Kathy had answered on a previous question about the difference between a senior and a junior. This person's commented that they think that senior junior is a junior barrister who is over 10 years cool. So I think that's a different view than the one you gave earlier, Kathy. I don't know if you want to comment on that, or one of the other speakers give a view as well.
Well, that certainly was the case with legally aided cases before you were on CCMS and the CF1A. Prior to December, whenever that was, you used to look and used to just charge an hourly rate. That's not the case on high cost cases, and that's not the case on CF1A cases. I have an awful lot of QCs that do junior work because they're not instructed as on QC rates, and they would just have to claim junior counsel unless it's specified. But that's my experience of it. I didn't, because you could previously you would claim £135 an hour as an argument prior to CF1As and CCMS.
Thank you. And then the last question that's come in is regarding payment on account contingency claims for old paper claims. Is this still in place, please? And if so, for how much longer, as we have some bills where a solicitor is substantially stalling on submitting, and wondered if we could submit for payment on account for work done by counsel on these cases?
Yes, is the answer, that the contingency is still in place. So that process is still very much there. How much longer it's going to be in place, I couldn't answer. The idea initially was that from the 21st of June, we would be winding down most of our contingencies in line with the timetable for the wider restriction lifting in relation to the pandemic. Obviously, as I'm sure we're all aware, that's been postponed by 4 weeks at least. And the agency has said that, you know, they would want to give providers 3 weeks notice of any changes that are made. So so it will be the 19th of July will be the earliest, but chances are they would probably go a little bit beyond that as well. But I can't say 100% because obviously we're awaiting to see what the central government decides to do in respect of the wider restriction lifting.
Thank you, Graham. And just another question is or another point's just popped up into the box. Contingency POAs, they comment, in my experience, if the LAA believe that the solicitor does not have a final bill in the pipeline, they have refused to pay the payment on account. Does anyone want to comment on that?
That's not my experience. We've got some really old cases where we've been able to get payments on account, going back years, SIAC cases. So that's not my experience.
Yeah, that's
give it a go.
Reassuring to hear. Thanks, Kathy. I mean, that is not my understanding of how the contingency was supposed to work. The idea was, you know, it's designed to assist providers and counsel through a difficult spot. And, you know, we shouldn't be throwing roadblocks up. So if you do encounter that kind of decision from a caseworker, I would, you know, if you could, I would appreciate it. It's not ideal, but if you could kind of go back and challenge it and ask them to reconsider it.
Yeah, I have to say from my experience that has never happened in any of my cases. I have one or two old ones, not many.
Well, I think that's a very happy and positive note on which to end the seminar. And I want to thank very much Kathy, Bob and Graham for their time for us all this evening. And as I said at the beginning, you'll be sent by our training and events team a feedback form and a copy of the slides of the presentations. So it just now remains for me to fall silent and wait for my colleague to press the button to terminate our seminar. And thank you very much, everyone, again.